My name's Kieran McManus, and we're here talking to you from the Brazilian American Chamber of Commerce. So we have an event which should go for about 1.5 hours, and we're going to discuss the implications of the SEC climate change rules. And we've a great lineup of guests here, and I guess without further ado, I'll ask the stars to present themselves here.
And it's great to be with you, Kieran, and the Brazilian American Chamber of Commerce today. And what brings us together today is the SEC's final climate change disclosure regulation. Every year we come out with our top 10 things that we're watching for the coming year. So one of the trends that we're seeing and that we highlighted in our last top 10 things article that came out this past January is the increasing cross-jurisdictional nature of ESG. You know, increasingly companies that are based in one jurisdiction may be impacted directly or indirectly by regulation and legislation that's coming out in another jurisdiction. A really great example of this is, of course, the EU's Corporate Sustainability Reporting Directive. And I know many folks on the call today might have an awareness of that regulation or even find that they themselves are subject to it. But I think even beyond that, we see how regulation and legislation that is environmental, social, and sustainability related really moves through capital, right? Moves through the provision of capital. It also moves through business to business contracting. I think, Betty, over the past year, we've seen just an incredible increase in the amount of business to business contracting that addresses issues around environmental, social, and sustainability issues. And a lot of that is around the second thing that I'm going to come to, the second trend that we're watching, which is the rise in ESG related data, right? The hunger for ESG and sustainability related data, and the responsibility for it, right? A lot of these regulations are requiring companies to go out and get information that they haven't necessarily gotten before, either from their own operations or from their supply chain. And that's a little sneak peek on the third item, the third trend that I'm going to highlight in a second. But I think this need for data is we're seeing that track to an increased demand for expertise in environmental, social, and sustainability areas. So many of the folks on this call, you might have within the past year or 2 years hired your first external consultant or your external law firm, or your assurance provider around environmental and social and sustainability issues. You know, we're seeing the need for greater and greater levels of expertise, both internally at organizations and externally as companies look to manage this information and this data. And similarly to kind of the first trend that I mentioned, we're seeing that reflected in contracting, right? We're seeing new types of contracts. We're seeing new types of responsibility, and with responsibility comes liability, right? And so we're seeing that track as well in the environmental, social, and sustainability space. And then finally, I would just mention, you know, we're seeing that increase with respect to the demand for visibility and transparency around supply and value chain issues. So many of these rules have implications, whether it's through scope 3 or through specific requirements with respect to supply and value chain transparency. They require companies to reach deep into their value chain. And in doing so, we see this regulation and legislation, right? That also becomes a vehicle for indirect effects throughout the value chain and throughout the marketplace. And with that also comes potential liability. And so I think those are some of the trends that I think make it really important to, regardless of whether or not you're subject to the SEC final climate rule, regardless of whether or not the final rule actually survives. We'll talk about that as well. But regardless of what happens, it becomes increasingly important to have your eye on environmental, social, and sustainability issues. So when we talk about scope 3, scope 1, scope 2, scope 3, we're talking about greenhouse gas emissions. That's what we're talking about specifically. A lot of the rules that are coming into play right now will require companies to measure and report on scope 1, scope 2, and some rules require also scope 3 reporting. Scope 1 is effectively direct emissions. It's what comes out of the chimney. It's a company's what they control within their operations, their direct emissions. Scope 2 is their indirect emissions within, also kind of within their control, right? It's utility bills. I think is one way to think of it. It's kind of a summary version. And then scope 3 is everything else. So it's potentially the full value chain of emissions. So for example, for scope 3 emissions, you think about an oil or gas producer, part of their scope 3 emissions, right? They have a lot of scope 3 emissions, right? Because we're still very dependent on fossil fuels in the world. And so, you know, when you get in your car and you drive to work in the morning, that's part of their scope 3 emissions. So that's the way to think about it. But because scope 3 emissions can, right, track through the value chain in that way, and requires companies potentially to reach deep into their value chain, that's part of the reason why I say it's a vehicle, no pun intended, but it is a vehicle for regulation and legislation to move through the marketplace.
You know, there was this whole push to try to get to a global baseline of climate disclosures, and you know, the SEC had tried to do that. CSRD, the European Union regime, is probably a little bit farther away from that. In California, kind of switching to the state of California, which I guess arguably is the 5th largest economy in the world by some accounts. California has 3 rules out there that are laws actually that are in effect. There are 2 of which are actually being challenged in court. But that being said, our clients, as a practical matter and from a market color perspective, are really looking at these and trying to figure out how they ought to comply with them. And so perfect segue when Kieran, you asked Sarah to explain what a scope 3 emission is, and she went through scope 1, 2, and 3. There's a California law that would require public and private corporations that meet certain thresholds and that do business in California to disclose their scope 1, scope 2, and scope 3 emissions. And that gets to Sarah's point about data. How do you get those scope 3 emissions, and how do you get all of this limited assurance on it? And so, you know, hopefully others will talk about the difficulties of, first of all, calculating that data and how painstaking that is, but then also getting, you know, a third party to assure that data. So it's kind of moving from non-financial disclosure into, you know, sort of financial disclosure. There's another law in California that's also being challenged, but our clients are very much looking at trying to figure out how to comply with it. And it's essentially requiring a task force on climate related financial disclosures report by, you know, clients, again, that are public or private, that have annual thresholds worldwide, annual revenues over $500 million, and do business in California. And I mentioned the task force on climate related financial disclosures, and hopefully I won't use too many acronyms today. The reason why I mentioned this one is because it in some ways serves as the backbone for that rule, as well as the SEC's final climate rules. So you've got that, this kind of mix and fragmentation of different laws with the EU as well. And then finally, last but definitely not least, is a set of kind of disclosure standards from the International Sustainability Standards Board. And there's one on climate-related disclosures. And it's important because many different countries, including Brazil, have signaled that they will you know, take that standard and make it, you know, mandatory in those jurisdictions. So thinking off the top of my head, you've got Brazil, the United Kingdom, Japan, Singapore, Colombia, and some other countries that have signaled. And so in many ways, you know, if I could say, you know, with a blunt instrument, you've got the United States and California, you've got the European Union, and then you've got the rest of the world, you know, looking at this ISSB standard. And what we're spending a lot of our time on is just kind of doing comparisons of all of the different disclosure standards, whether it's, do you use the greenhouse gas protocols? How do you define your organizational boundary of what a scope 1 is versus a scope 2 or a scope 3? are they all consistent and harmonious, or do you have to have different disclosures and different documents with respect to different jurisdictions?
Yeah, I mean, you know, one of the downsides to the SEC rule getting challenged is the point you raise. At least, you know, some degree of uniformity would have been good, at least to lower compliance costs. And since that's been challenged and it may actually never see the light of day, I don't know. You have a system where you have fragmented regimes, the point you made, right? So the fragmented regime problem, until the politics in the US settle down, and they will never settle down, I think this is a reality. So that's the first point. And second, you know, you also run the risk of letting the EU become your default regulator, which is increasingly the case in the US. If we can't agree on regulating, then somebody else does. And these are all multinationals. I mean, you saw the case with the Apple, what was it, that USB thingy, remember? When Malta or somebody, a small state in the EU, objected, and because of scale economies, Apple had to change the rules for everyone, which is a good thing by and large, right? But there's also the danger that you're effectively conceding the debate to somebody else outside your system. This is the whole issue with IFRS and US GAAP. You know, US GAAP will never go away because we politically don't want to concede this much power to a European entity to write rules for us. But that's what you're doing by fighting like cats and dogs here, both sides, about climate rules. So some of it is going to be by default. Some of it is, I mean, fragmentation is sadly inevitable. Compliance costs and administrative costs are massive. It's good news for lawyers and accountants because it keeps us in business.
I often wonder in these discussions about net zero, you know, it doesn't look like the technology exists today to get to net zero. So whenever you're signing up on something like this, I mean, you're signing up on, I hope that solutions will be developed in the future. But you know, a lot of companies are signing up to net zero, and you know, and if you're in the supply chain, you have to sign these contracts to get business. You know, you're making major commitments, and I'm sure that Sarah and Betty are putting in fines and other clauses in there, the penalties to in case these are not met. So it looks like it's a difficult choice for for these companies in this line of business, of the supply chain.
And there are certain technologies that we don't have yet. There is certain infrastructure that we don't have yet. And so I think I do, Betty and I also spend a lot of time helping clients think about and navigate greenwashing, which is really, I think, what you are talking about in part, whether we're talking about greenwashing or social washing. It's that practice of, talking about your practices around sustainability in a way that is potentially misleading or shades things in a way to suggest that your operations or your supply chain are more green or more virtuous than they are. And the question then becomes whether or not they're more virtuous than they can ever be, right? I mean, given our limitations from a supply perspective and given current limits on technology.
Okay, it's great. And maybe Sarah or Betty, like, I guess coming back to the SEC climate rule, there's a lot of I guess a lot of discussion and there appears to be legal dispute about this. But in terms of, there appears to be general agreement that the investors should receive all of the material information they need in relation to climate change, and if that's if that's an agreement, why is there so much discussion and legal dispute about the information that is material to the investor? What should be made available to the investor in terms of, in this particular case, in terms of climate change?
Yeah, I can give a little bit, and then I'm sure Sarah and I and Shiva will go back and forth. But there are a couple of things embedded in there. And it's not to say that I agree with this, but just answering your question factually. There's no uniform investor, right? There are many different types of investors. And some would argue that in some of the releases or the proposing release or the adopting release, I'm not taking any sides at all, some could say that the footnotes cited to, a particular type of investor as opposed to other types of investors. And so that was a criticism to say this was not fair and balanced, but really more focused on sort of the ESG-minded investors who have very different agendas and very different interests than, other types of investors. So that's one. And then number two, the definition of materiality is, very well settled under US securities laws. But then when you have something like the European Union Corporate Sustainability Reporting Directive that has basically enshrined this concept of double materiality, which is impact and financial. And if you read their latest guidance on double materiality assessments, it really blurs all of like financial and impact materiality, where you sort of say, what on earth is material anymore? And then, for the longest time now, for 5 to 7 years, corporates who are subject to the US securities laws were putting out or continue to pull out voluntary disclosures under the Global Reporting Initiative or under the Sustainability Accounting Standards Board, and using this term materiality assessment, which further, kind of blurs what materiality is. And so I think, as a securities lawyer by training, I am very confident as to what I believe is US securities law, but with all of this other stuff going on in this global landscape that we've been talking about for the past half hour, it makes it very difficult to say, well, what investor are we talking about and what type of materiality are we talking about? I think also, sort of all of the debate really also is just because as much as I understand what securities law materiality is under US securities law, we also understand how much liability could be attached to any kind of securities law filing. So I think there was, real discomfort and anxiety by issuers who'd have to put out this disclosure, putting aside how expensive it would be that we've already talked about, but also the liability could come out of like, good deeds. All of our clients are doing this in good faith and trying to do the right thing, but acknowledging that, with increased disclosure obligations, particularly of scope 3 emissions, which are not something that they have necessarily control over, and taking strict liability off of that is just really kind of untenable. So those are, the broad strokes, broad answers to your questions, Kieran.
So I just want to go back to Betty's idea of different types of investors and add a time dimension to this, because to me, climate change by and large is a slow burn problem. It'll start affecting earnings per share 15, 20 years from now in big, substantial ways, let's say. And if my horizon is the next 3 months or the next 6 months or next 1 year, it's not material. So I'm going to complain my head off saying, oh, this is all a waste of time. But if I'm a universal owner of some kind and I have to hold the stock because I'm an indexed investor for the next 30, 40 years, until the index company kicks out the company from that index, it's going to matter to me. So there's that other dimension here. When you write securities laws, and I'm no lawyer, what does material mean? Is it for the 3-month investor, 6-month investor, 60-month investor, 10-year investor, 20-year investor? So that's the first question. I think some of the dispute arguably is one of horizon. And the second point, if you break down climate risk, you're talking about physical risk and transition risk. Physical risk simply means floods and so on, right? And I've run some data. If you look at the big named storms in the US, the named disasters, it doesn't have to be storms. There's not a lot going on from a cash flow or a stock price perspective for public companies, which is where most of the conversation is centered around. But there's something going on with private companies, and it's not that difficult to think about, right? So if there's a massive snowstorm and Brooklyn shuts down, the sandwich shop doesn't sell sandwiches for 3 days. Their sales really get hurt, but they're not public, they're small, they're not insured. So I think so there's another issue in terms of maybe beyond the scope of this conversation, but a lot of the economic risk is arguably sitting somewhere else, not necessarily with public companies. It's sitting with small private companies, which are outside the scope of securities regulation and so on. Transition risk, on the other hand, is a bigger concern, right? So if California or somebody says no more electric cars from 2030, that's massive for a GM or a Ford, right? How are you going to adapt? And by and large, disclosures of those kinds have usually been non-existent to horrible. The company has to tell you what kind of business model are they getting into, what does future cash flow look like, and so on. All this, to me, should be under the ambit of climate risk disclosure. I think we have overdone emphasis on scope 1, scope 2 metrics. just step back and think a little bit more about the economics in terms of both the horizon, in terms of where the risk sits, and in terms of fairly poor disclosure when it comes to things like transition risk.
One thing that we haven't talked about is just like maybe pre-IPO companies. So maybe there's some in the audience right now. We've been speaking a lot about like existing public companies, and Shiva talked about some private companies. But a big part of our practice, Sarah and mine at Latham, is advising pre-IPO companies, and so the IP markets are back, and so that might be provide a really nice example of currently private companies who are under certain pressures to provide ESG information, whether it's they're sponsor held and they've got private equity limited partners who are requiring certain things, and suddenly they're like, oh, now we have to face the public markets. What does that mean for us? There are ESG raters out there that require this type of information. If you want to get a good rating, they compare you against your peers regardless of size, and so we're often looking at sort of like pre-IPO companies or smaller companies being compared to larger ones that are in their industry and just feeling like they can't compete. And so I think to that point, they're feeling pressure to put forth more of that information as you just described. And then without getting into too much detail about the dynamics of IPOs and all of the different players involved, oftentimes they'll feel pressure to get put out more information so as to access the green share of the wallet, and access like a different base of investors. So we see that time and time again, and we're often consulted as lawyers to say, okay, how do we provide this program? How do we provide that governance that we just talked about that didn't exist before? How do you put that in top down on an organization that's been doing just fine without it? And then how does that translate into the disclosure in the registration statements? And I'll say for sure at Latham, when the SEC final rule came out on March 6th, the very first question we got from our corporate finance colleagues and banker clients were like, what is this going to do to the IPO markets? Unfortunately, the answer was, not too much. Disclosure won't be required immediately. But, I just wanted to kind of give that perspective if that was relevant to the audience here today.
Sure, right. I mean, anytime the rule maker proposes specific rules, the other side, and I'd want to name them, will often come back and say, oh, the US disclosure regime is robust. If there's any risk, it's required to be disclosed. Why do we need more rules? Right? But both sides sometimes don't engage with the data. I'm just going to come back and talk about simple things, right? So if you look at what is taught in a high school economics textbook, how do we create value? It's some combination of materials, labor, capacity, managerial talent. If you take that framework to our $1 trillion market cap companies, it's impossible to know what's going on. Most people don't tell you what materials are. 15% of US companies tell you what labor costs for their company might be. We know very little about managerial talent. It's like a 6-line description and a proxy statement in terms of what the CEO does or where he or she came from. We know very little about capacity because we need maintenance capex, meaning what do you need to spend to just stay where you are as opposed to the depreciation number. So the idea that in the abstract, the rules are great and they require you to, disclose a lot is all fine. In practice, I don't know anything about how companies actually add value or create value or distribute value. So that's one point I want to make up front, because you simultaneously have over disclosure and under disclosure. You have under disclosure in terms of things that matter, and you have lots of pages of the 10K proxy plus the sustainability report combined for most companies is probably like 500 pages, right? So I think we simultaneously live in both realities, I think is the answer to that question. So why do you need 900 pages? Maybe 900 pages is overkill. But at the same time, the counter argument that the disclosure regime is pretty robust and it requires you to already tell you everything that you need to know is also playing fast and loose, and they don't necessarily engage with the data. So you do need, and the other way to frame this is rules versus principles. In principle, you're supposed to tell us everything, but it doesn't really work out in practice. I mean, you can talk about the human capital rule, which is not necessarily the conversation here that we're having, but the previous regime said, in principle, just tell us what are you doing with human capital. Yeah, I mean, people basically have boilerplate disclosures with a lot of words, except I don't know something as basic as labor costs. Do you know of any company that doesn't know what its labor costs are? That's like, essential to running the business. And if you don't know what your labor costs are, then how do you manage your business? But we don't see reporting on labor costs. So principles are wonderful, but unless you have some specific prescriptive guidance, you don't see disclosures, is one way to think about your question.
Okay,
Yeah.
that's great. I think we've come to the end of our time here, and I see we have another question here about the recording, and the recording will be made available to everybody afterwards. And I really thank everyone and for participating today, and also for the BACC for organizing this event, and for everyone here who's helped organize it behind the scenes. So thank you very much, everybody. And I think with that, let's close off the event. Thank you.
Thank you so
Thank-
much. Great to see you all.
Thanks.